First of all, let me explain the program a little bit to you. I know some of you have participated in it before. Can everyone hear me, first and foremost? Okay. As Amanda alluded to, you'll receive a case, and it'll be either criminal or civil. And I will say the national case is a criminal case this year. And so, although I'm not at liberty to necessarily disclose what this particular case is, I think the cat might be out of the bag. But that's okay. I did fail to mention that I'm so looking forward to my new partner really starting to come into working with me and presenting these clinics, and that hopefully we'll be able to offer even more as the years progress to help you prepare for your program. As Amanda stated, you will prepare both sides of the case, and you will prepare the prosecution or plaintiff side or the defense side of the case. You'll prepare both. And you'll need witnesses and you'll need lawyers. And every person is key to your success in this program. So if you're identified as a witness, don't be upset about it. Take it, embrace it, practice your acting skills. And I'm hoping today that you'll get to see, I'm going to show you some clips from the national finals competition. I personally was so impressed with the people that were on, that I have practiced with people or I've been in trial with people who aren't that prepared, aren't that eloquent in the trial room, in the courtroom. So I'm really excited to show you these clips today. But what I wanted to start with is some very basic information. All my cutesy stuff in my PowerPoint presentation. So let's start with the basics. There are 4 basics applicable to all trials. First, you must understand basic storytelling principles. And you must prepare a persuasive trial story. You must use appropriate trial technique tools in planning your case and keep the proper demeanor in the courtroom at all times. So let's talk about those. How do I prepare a persuasive trial story? Well, first, there are 2 crucial elements to telling a persuasive trial story. 1, you need a theory. What is a theory? A theory is a single paragraph. Well, a theory should be able to be encompassed in a single paragraph which takes the facts of your case, the applicable law in your case, and leads the jury to a conclusion that your client should win. I call this the cake. Most people don't like cake by itself. So what else do you need? You need the frosting. The frosting are themes. There can be more than one theme in a case. This should be no longer than one sentence which appeals to shared values, civic virtues, and common motivations. So what does a theme mean? Well, a theme is like your word is as only your a handshake. My word is my handshake. If I say I'm committing to, if I shake your hand, then I've committed to do what I've told you I've committed to do. My word is my bond. Those are themes that you use in a case, but it's not your theory. Your theory has to have where you have the facts of the case and you understand the law sufficiently that you know that you meet each of the elements of the law and that you can tell a story that using those facts and those law that persuade the jury to rule in your favor. You need to use appropriate trial technique tools. What are those? Tools that are applicable to all stages: sequencing and repetition and duration. So now you've got your theme, you've got your theory. Well, your theory needs to flow throughout your entire case, starting with the opening statement, all your direct examinations, your cross-examinations, and your closing. How you sequence the facts, how you sequence their applicability to the law is important throughout the entire trial. Repeating your themes, throughout those segments of the trial are also important. So don't just use your themes and theories in your openings and your closings. Use them throughout how you organize your direct examinations and how you organize your cross-examinations. And this seems kind of broad, but we'll get into the specifics of how this applies to each of those as we cover each of those topics. consider this the single most important thing. You always need to keep the proper demeanor in the courtroom. You always need to show respect to the judge and to your fellow attorneys. Your integrity is the single most important tool that an attorney can bring to the courtroom. If the jury doesn't believe you, they won't believe your client. So your integrity, you need to make sure you don't misrepresent the facts to the jury. You need to make sure you don't make promises to the jury that you know you can't keep. Because it might sound really cute in your opening statement, but that jury is always paying attention. And in mock trial, your jury are your judges. Confidence. You need to exhibit confidence in what you do. That sounds easy, right? No, it's not. But I'll tell you, what I have found to be the single most important thing to do to prepare myself to be confident in the courtroom is preparation. Preparation and organization. If I know the facts better, if I know the law better than my opponent, I'm going to be able to walk in there confident. And no matter what my opponent pulls out of their bag of tricks, I'm ready for them. And that requires preparation. And you're going to need to make sure you dedicate the time to understanding each of the witnesses' statements, even if it's not your witness. Even if somebody else has been assigned that witness, if you don't understand that witness's statements and the facts that witness is bringing to the table, then you can't be prepared enough to cover any topics that arise while you're examining your witness. So it's important you know every aspect of the case, regardless of whether you've been segmented to opening and one cross-examination or opening and one direct examination. You need to be able to cover all of them. So let's get into the meat and potatoes of this. Let's talk about opening statements. It's an opening. It's your first opportunity to tell the jury your side of the story. And you need to use that. And it's a statement. What does that mean? That means you shouldn't be arguing. Save your argument for closing statements. And this is a pretty fine line. It's okay to walk in and say the evidence will show this, we're going to show you this, you're going to hear this. Those are all okay because those are still statements and they're not argumentative. But if you start arguing the biasness of a witness or this or that, you're going to get into argument and you're probably going to pull an objection from the other side. So leave it. Just make a story. Tell a story. Tell the jury your story. Your goals for an opening statement. This is the first time you get to put your themes out there in front of the jury. Juries catch on to things. My word is my bond. It's a contract dispute. It's an oral contract. It's not written down. My word is my bond. He told me. His word was his bond. Those are things that you want to carry throughout. You need to demonstrate your credibility to the jury. Once again, if you come in through the opening and you say, the evidence will show this, and the evidence is going to show this, if you don't show that jury what you said in your opening, they're going to remember. You didn't show them. And your credibility is out the window, and so is your client's. So 3 tips for establishing credibility during an opening statement. Tell your client's story to the jury. It's your client's story. It's not about you. So let's keep that in mind. Don't tell them what you think. Tell them what your client thinks. Tell them how your client felt. That's important. Not what you think, because you don't want to place that out there. I think this, or I want this, or I decided this, or any of those things are completely inappropriate. Tell your client's story from your client's perspective. Tell the whole story. What does that mean? There are going to be bad facts against your client. You need to get those out there and address it. It's like if you are the first person to bring it up and you get the first opportunity to explain it, then you don't have that. That jury's not getting to hear it for the first time from the other side. And their story is going to be completely different, and their explanation is not going to be good for your client. So go ahead and get that bad fact out there and explain it to the jury. You may hear this, and if you do, this evidence will show that it's not true, or something along those lines. But don't hide it. Keep it strong and safe. Once again, if you're not sure about certain facts, whether or not they will come in, because you don't know whether or not you're going to be able to meet the evidentiary burden to get that piece of evidence in, don't bring it up in your opening statement. Stick with those things you know you're going to be able to get in. Because once again, if you don't get it in, the jury's going to remember, and your credibility is shot. So what does that mean? That means if you're following up, so you're not the plaintiff, but you're the defendant, and the plaintiff's team's already gone, and you get up and you heard something in the plaintiff's opening, and you've got your opening all drafted up and you've memorized it, which I don't recommend. You should probably have bullet points instead of memorizing an opening statement. And you hear something you hadn't thought of before, but you know how to go ahead and address it, not argumentatively, but to say the evidence will show this. You heard the plaintiff say this, but the evidence we're going to show you, the evidence is going to show you this. So you need to be prepared to wing it. And if you've got a memorized opening statement, you're not going to be able to wing it. You're not going to be able to listen to how that whole, and that applies to the entire trial. You need to not be so routine that you can't, and so choreographed that you can't adjust, because each team you come across is going to have addressed this in a different way. And so you need to understand the facts so sufficiently, and the law so sufficiently, that when someone throws something at you that you hadn't seen before, you can wing it, because you're not so scripted. This isn't TV. So all the things you see on TV are scripted. Keep that in mind. They already know what's coming down the pike. Save the legal terms. Don't use legal jargon. Juries don't understand it. And like I said, your judges are going to be sitting there. Most likely they're going to be attorneys, but they're not going to be impressed necessarily by your use of legal jargon. So don't do it. Be specific. Point to specific pieces of evidence. Tell the jury specifically what you're going to show them. Get their attention. You can use a theme to get their attention. You're going to see that in a minute. I'm going to show you, and we can talk for a second after, and I'm going to show you a clip. I picked this particular clip because I felt like the lawyer was using themes so well, and I thought it was an excellent demonstration of how they had a theory of the case, how they demonstrated it to the jury, and how they used themes that caught in your mind. That's what a theme is, and that's that thing that gets the jury's attention, and that's the thing they remember throughout the entire trial is that theme. And try to avoid objections. That means don't be argumentative, and you'll avoid objections. So let's.
When you're addressing witnesses for the court, so you may draw closer to the jury than the voting.
Thank you, Your Honor. May it please the court, counsel, members of the jury. Promote, protect, preserve. The United States of America has a rich history of shipping and shipbuilding. The Port of Wilmington is at the heart of the shipbuilding industry. In 1965, a young man named Pat Penn, who barely had 2 nickels to rub together, followed in the footsteps of those who came before him. He looked out across the dock and had a vision to create what is now Delaware Auto and Marine, which today we will be referring to as Delaware Marine. He did not know then that nearly 40 years later he would be required to fight in order to promote, protect, and preserve the values which we as American citizens hold dear. Pat Penn lives the American dream. Mr. Penn, would you please stand? With honesty, hard work, and determination, Delaware Marine grew under Mr. Penn's leadership. In 1985, the small company was so successful that it began trading its stock on the New York Stock Exchange. No one knows the inner workings of the Port of Wilmington and the marine cargo business like Pat. Thank you, Mr. Penn. Like many American businesses, Delaware Marine felt the devastating financial effects after the attacks on its nation on 9/11. Mindful of the best interest of their stockholders, the board of directors at Delaware Marine designed a strategic business plan developed to revitalize the company and the port. By judging the shipping lanes of the Delaware River, larger vessels could enter the port. Larger vessels means more cargo. More cargo means more profit, and more profit means higher stock prices. They will revitalize the company, and Delaware Marine will go from being a good company to a great company. However, while the board of directors at Delaware Marine was planning the revitalization of the port, other more sinister plans were afoot. on a small island off the coast of Oman, a nation called Aladdin was teeming with activity. A company from the country of Aladdin, Many Stevedore Services, which today we will be referring to as MEX, was plotting to take control of the port of Wilmington. While this nation was recovering from the attacks on 9/11, efforts were underway to launch a hostile takeover of Delaware Marine. MEX's offer was intended to appear attractive to some, but today you will learn that MEX's offer is not in the best interest of Delaware Marine stockholders because the offer significantly undervalues the worth of this fine company. Today you will also learn that MEX's offer is not in the best interest of national security because MEX has material ties to terrorism. Aladdin owns and controls MEX. Evidence will show that the Prime Minister of Aladdin is a known associate of the international terrorist, Bruce Harris. The same international terrorist who has murdered hundreds of people. The same international terrorist who has injured hundreds more. And the same international terrorist who is the brother of MEX's president, Devereux Terry. Devereux Terry has expressed his hatred for the United States, saying it would bring him great pleasure to see America attacked, where innocent Americans will be killed. We intend to prove, by a preponderance of the evidence, that MEX has material ties to terrorism. If MEX controls the port of Wilmington, American ports and American interests will be vulnerable. If MEX controls the port of Wilmington, national security will be in jeopardy. The board of directors at Delaware Marine has a duty which requires them to resist the offer by promoting their business plan, preserving the values of Delaware Marine, and protecting their stockholders. At the conclusion of this trial, we will ask you to find in favor of Delaware Marine. We will ask you to help the board of directors promote their business plan, which is in the best interest of their stockholders, preserve the marine cargo heritage at the port of Wilmington, and protect the United States of America. Thank you.
Can anyone tell me what they thought was the, could they pick up what the theory of the defendant's case was in this, by this opening statement? Go ahead.
Probably to preserve American values, some sort like that.
So basically, that what they did was to protect America? Would you say that? Okay, so they basically aligned themselves with the same vision America has to protect itself from terrorists, right? So what's a theme? What was the theme that you picked up on? It's kind of along the same lines you were talking about too. Okay, well, help. How about promote, preserve, protect? Promote, preserve, protect. You heard her start with it, you heard her use it, and she closed with it, right? But she started with, this is the thing, this is America's, this is how we feel about, the American government feels about protecting its people. This is what they do. And now at the end, this is what our company did. We are promoting the business. We were protecting our shareholders. We're preserving the company. So that's what I'm talking about. Those things, and if you watch the entire video, and it will be available to you if you'd like it, when they're really good at using those themes and theories and following it through the entire case. Both of them are, because the plaintiff's theme is poison pill. So they use that as well. So it's kind of interesting to see it happen, but you also see him close it up. And I mean, that's what makes these two the finalists in the national competition. Okay? And you can tell the confidence she exuded. That was from preparation only, preparation and practice. So if you want to be those two teams, those are the things you need to do. So let's go on to the opening statement. Does anyone have any questions before we move? Yes?
How long ago was that?
This was last year. This was May of this year. So we're going to move on to direct examination. Okay, most trials are actually won based on the strength of your own case, not the weaknesses of your opponent's case. So many people think, well, if I can just cross-examine their witness, it doesn't matter how bad my case is. It's just not true. It's just absolutely not true. So you need to make sure that your direct examinations get your case out. Use your cross-examinations will benefit you. They need to be as equally prepared, but you need to be able to put forth your story through the evidence. Yes, you've got to say your opening statement, but that's not evidence in the case. You've got to be able to put all your evidence in through your witnesses. So you need to be prepared that any piece of evidence you want in the case needs to come in through your direct examinations. They must be clear. You must be able to tell, the jury must be able to perceive what you're trying to tell them from this witness. So you need to be asking the questions that get your witness to tell their story. Direct examinations must present the facts of the case. Once again, facts, testimony is evidence. There's physical evidence as well. So both, you need to be able to get the pieces of paper that you need to have in your case, as well as the facts of your case through testimony during your direct examination. And we've talked about this, and I don't mean to beat a dead horse, but your theme and theory must run throughout your direct examinations, each of them. So the elements of an effective direct examination are what? Keep it simple. Use logical organization. We'll talk about that as well. Use logical sequence. So that's the same thing. And what I'm saying here is that's all fact dependent. It depends on the story you need to tell. So if the story is about someone personally, then you need to get their personal background information. If it's about an accident, we need the scene description. You can't bounce back and forth from describing the scene to the person's personality. You need to be able to organize your direct examination so that you're leading the jury to the ultimate conclusion that this witness's story adds to your ultimate trial story. You need to make sure you include action description. And you need to make sure you introduce evidence, exhibits supported by the witness. And you definitely don't want to forget, if you're the plaintiff in a civil case, if you want damages, you'd better make sure you introduce the evidence of your damages in that case, and through your witnesses, because you have no other opportunity. And in trial practice, if a plaintiff has the burden of proving the case, if they, through the end of their testimony, through their witnesses, have not done so, have not introduced the evidence sufficient under the law to meet their burden, the defendants always move. How my brain just escaped me, I'm sorry. They move the court to directed verdict. Thank you so much. I had a brain blurb. Sorry, a directed verdict, which means, Your Honor, the plaintiff hasn't met their burden. They haven't introduced sufficient evidence to meet their burden, and therefore you need to enter a verdict immediately before I put my case on. What is the role of direct examination? Well, you want to be able to introduce your undisputed facts. You need to get all the undisputed facts in during your direct examination. You need to put forth your client's version of the disputed facts. So this is your client's version. You need to get those out. And once again, this all goes to getting the evidence in that supports your burden. You need to lay the foundation for exhibits. So a witness, and I'm sure that your coaches will help you with this. Evidence, we could have an entire workshop on evidence. How to introduce evidence, how to deal with rules. You need to be so intimately familiar with the rules. The rules are key to separating you from another team. Your ability to understand objections, when to make them, how to support them, how to lay the foundation for exhibits are all key to your success as a mock trial team. So don't think that since you know the case so well that you're just completely prepared, because if you've got someone objecting to your introduction of testimony, you need to justify to the judge why you have laid the proper foundation for the exhibits, why this witness is competent to testify about these particular things. So know the rules. And you need to reflect upon the credibility of the witness. If it's your own witness, you need to sort of lay out why. If you know that the other side's going to try to talk about bias, your witness is the best friend of the plaintiff and would lie through their teeth for him, that's what this defense is going to say. You need to be prepared on your direct examination to go ahead and try to get the credibility of your witness out there so that the jury automatically believes them, and when the defense comes to try to attack their credibility, they've already got this image in their mind that this is a believable witness. And one of the keys in that last statement is that those bad facts again. If you've got bad facts and it's specifically related to this witness, your direct examination needs to address those bad facts. You need to be able to give your version of why those bad facts aren't going to infer what the other side wants them to infer. So get those bad facts out there. Cover them so that your witness can explain why, yeah, I may be their best friend, but I'm not the kind of person who would lie for my best friend, no matter what. Rules of direct examination. We talked about witness must be competent, must possess personal knowledge of the material issues of the case. You cannot use leading questions. Some of you have already participated in mock trial. That's hard, isn't it? It's hard when you're doing a direct examination to not just tell your witness, well, isn't that true? I mean, that's what makes to some people cross-examination so much easier. But really, direct examination, once you understand it, can be really easy because all you have to do is ask the questions that allow your witness to tell their story. Who, what, when, why, how. Listen, and listen to your witness. Because while even your witness is up there and you guys have prepared, there may be something that they say and you need to, or they misstate something while they're sitting up there on the stand, you need to be listening. Even though you've prepared and you and your witness have worked together and worked together and worked together, always be listening. Because what if your witness says something you didn't expect? Has that happened? Yeah. So your own witnesses said something you didn't expect them to say. Well, tell us about it. Kind of give us an example.
Well, we basically had our witness up there, and the other side asked her how many pills she had taken of the antidepressants, and she said 3.
And how many had she? And was that a surprise to you?
Yeah, because that's not good.
I hadn't read the doctor's report and stuff. Like, I didn't think about it.
So now you know this year, though, that whatever witness you're assigned, that
I'm reading everything.
That's right. That's right. For that reason, exactly. So that's the same thing. It can happen to you too on direct examination. You could ask your own witness that question, or you could ask them a question, and they're just telling their story, and the next thing you know, something that's you weren't expecting comes out of their mouth, and you've got to address it. So always be listening. If you're just looking at your script, you're going to find yourself in a little bit of trouble, but I promise you the other side's listening. But just remember who, what, when, how. You're trying to tell a story. So let the witness testify. You're not testifying. In direct examination, the witness is testifying. In cross-examination, the attorney's testifying. There are a couple of exceptions to non-leading questions, preliminary matters. You're a teacher, isn't that correct? I mean, it's just the basic stuff. It's not objectionable. You know, you've got 3 kids. I mean, those sorts of things are not objectionable if they're not at issue in the case. So you can ask direct questions to get to the point real quick. Once again, issues that aren't in dispute. And if you need to direct the witness's attention to a specific issue. So how do I plan my direct examination? This is the nuts and bolts of it. There are 11 elements to an effective direct examination. First of all, you need to know what to include in it. You know, after you've read everything in the case, what do you need this witness to say to tell your trial story? What facts need to come in? Okay, what does this witness not need to testify about? You know, what's not important that this witness testify about, so you don't need to address it. You know, you don't need a long history about their college experience if it has nothing to do with the case and they're not an expert witness and their expertise is, you know, they're not testifying about their expertise. You don't necessarily need to have their entire educational background. use topical organization. We sort of talked about that. If you're talking about an accident, you need to have all the accident questions and that testimony all together so it's cohesive for the jury. So don't interrupt the action. Your witness is telling the story. They're completely engaged in it. They're going a little longer than you thought. They're doing a fantastic job, but you're like, oh, I got time because this is mock trial, and I've got questions to ask. I'm going to interrupt. Don't do that. You need to look at your witness. Like, okay, come on, you need to hurry this up. And if you need to go back to your examination, and you need to cut out something that's a little extra to make up the time, then do so. But don't interrupt the action. Don't interrupt your own witness. If there are specific details, give each of those details, if they're specific details and they're important details, let's say that, give each of those details the attention they deserve. Don't scatter circumstantial evidence. If there's several pieces of circumstantial evidence that lead you to a conclusion. So circumstantial evidence is not direct evidence. So I've got I'm trying to get the jury to come to a conclusion based on several facts. I need to put all those facts together so that the jury comes to that conclusion. So if it walks like a duck, it talks like a duck, then it's a duck. So I want to leave that, and that's really simple, but I want to talk about the duck walking like a duck. I want to talk about the duck talking like a duck, so that at the end, the jury concludes, along with my witness, that it's a duck. And use defensive direct examination. We've talked about that. That is, I know there's bad facts out there for this witness. I need to address them in my direct. If I put my head in the sand like an ostrich, somebody's going to beat my witness upside the head, and it's too late. If the first time a bad fact comes out is on cross-examination, it's too late to clean up the mess. You need to cover that in the front end. Don't hide from the bad facts. You need to address the good facts before the bad facts. Okay, so get your story out there, then deal with all the bad stuff. You want to get to the point, so don't prolong it. I'm trying to get to the point myself, so and help you guys out. Hopefully I'm not skipping anything. End with a clincher. So end with something that's really important to your case. So you've started with your good facts, and then you deal with the bad facts, and then you save that clincher for the end. And if necessary, because it doesn't suit the purpose of the case, ignore whatever you need to ignore out of that. So if it doesn't seem logical for you to follow, and these aren't cut and dry rules, so if it doesn't seem logical for you to work it that way, then don't. So let's watch what I considered a good direct examination and a good witness, because you're going to play a witness. This guy, he's a hoot. I'll just tell you that right now. And I love him, and I think that and I've judged a couple of these, and I think that when you're the judge, when you see someone who has really taken to heart their role as a witness and it plays out to almost be real to you, that's a good witness, and it works well for your case. So let me play that for you.
Brett,
Yes, ma'am.
you are, as you testified on direct, you are aware of Delaware Marine's business plan to drive this shipping lane.
That is correct. Obviously, no evidence that's going to happen.
If Delaware Marine's plan to drive is successful, are you currently employed?
Well, no, ma'am. I retired 6 months ago after giving DAM a good 40 years.
Now, what was your original position at the company DAM?
Well, I started off as an office worker. Pretty much did whatever my boss told me to do. Did a lot of errands. My boss told me to make him coffee. I would ask how many scoops he wanted, scoops of sugar he wanted. He asked me to pick up his laundry in his car. I would do just that.
Did you have any other aspirations within the company?
Yes, ma'am, but you can imagine that necessarily wasn't my dream job. I always wanted to work on the docks where they unloaded and loaded cargo from around the world.
Did you eventually become a dock worker?
Yes, ma'am, I did.
And at the time of your retirement, what was your position on the dock?
I was a warehouse foreman, where I directed the unloaded cargo into the various warehouses.
And Mr. Sussex, while warehouse foreman, did you work for any particular port?
Yes, ma'am, the Port of Wilmington.
Can you please describe the Port of Wilmington for the jury?
Yes, ma'am. If I had to describe the Port of Wilmington with one word, it would definitely be busy. We handle 400 vessels per year, and it occupies approximately 300 acres of land.
How many warehouses does the port have?
About 5 warehouses, 2 of which are temperature controlled.
Now, during your employment at the company DAM, were there ever any security breaches?
Yes, 2 big ones to my knowledge.
Can you please describe these incidents for the jury?
Yes, ma'am. We had some yahoos sneak into our warehouse and steal some tennis shoes from one of our warehouses. We ended up having to get that fixed. And then we had a severe fire ant problem with a shipment of bananas from South America. It's a pretty big deal. We had to call bioterrorism authorities and custom agents.
Are there any specific safety requirements at the company DAM?
Yes, ma'am. DAM requires employees to wear identification badges to allow them to gain access to the various warehouses.
What are these badges exactly used for?
But they're supposed to prevent unauthorized personnel from getting in. But I will admit, I did use my children's identification badges to get in to see some of my good old buddies.
How would you describe your experiences at the company DAM?
Good company to work for. That's why I spent my 40 years there.
And who is the founder of DAM?
Mr. Pat Kent.
Have you ever come in contact with Pat Kent?
Yes, I would run into Mr. Kent on the docks and we would have conversations.
Mr. Sussex, are you familiar with Jamie Newcastle?
Oh, I'm familiar with Newcastle.
Now, what is Mr. Newcastle's position at the company?
Surprisingly, he's the head of security.
Can you please explain to the jury exactly why you just stated surprisingly?
Yes, ma'am. Back in those days while Newcastle was working, there was a bit of a pilfering problem.
Can you please elaborate?
Yes, ma'am. A couple of years ago, while Jamie and I were working for DAM, we received some Sony televisions. We had them sitting out in the warehouse. It was some good televisions. They had all these gadgets and gizmos on them and buttons. I mean, because back in my day, we had to get up from where we were and go up to the knob and had to turn it. They had this big thing in the back and the gravity. Nonetheless, they were good televisions.
Now, were you ever able to observe these TVs in stock again? Or were you ever able to see these TVs again?
Yes, Jamie invited me to go to a Super Bowl party that he was hosting, and I noticed the same television that we received at the warehouse, same make and model and everything. So I went up to Jamie, and I asked him, hey, where'd you get the television from? Just out of curiosity. He told me Sears.
Did you eventually go to Sears?
Yes, ma'am, to try to compare the prices. I wanted one myself. It's a nice television.
Mr. Sussex, were you able to observe these TVs in stock and compare the prices?
No, ma'am. They weren't even in stock yet. Kind of gave me the raised eyebrow about Mr. Newcastle.
And Mr. Sussex, have you become aware of an offer that NESS has proposed to DAM?
Yes, ma'am, $20 per share.
And when you first heard about this offer, what did you do?
Well, I emailed Mr. Kent, hoping that he would protect a long-standing family member.
Did you get a response from Mr. Kent?
No, I received a response from one of his assistants. Guess he didn't have time for Mr. Sussex.
Your Honor, let the record reflect that I'm now showing opposing counsel has been 3 months in Exhibit 6. May I report for identification purposes?
Yes, please.
Mr. Sussex, without going into the contents of Exhibit 6, can you please identify Exhibit 6 for the jury?
Yes, ma'am, this is a response I received from Mr. Kent's assistant.
Your Honor, at this time, the plaintiff tendered Exhibit 6 into evidence. Its accuracy and authenticity have been stipulated. No objections, Your Honor.
It's submitted.
Yes, Your Honor. Now, Mr. Sussex, can you please read aloud to the jury the response that you received from Pat Kent's assistant?
All right, now I didn't bring my glasses today, but I do my best shot. All right, dear Aaron. Mr. Kent asked me to respond to your message. As you can imagine, Pat is very busy right now, but asked me to tell you that it's not happening. Perry White and Lois Lane are among Pat's closest friends, and he intends to make sure that they will act appropriately to dispose of Aladdin scandalous offer.
Mr. Sussex, was there any particular reason that you think Pat Kent is evil?
Yes, ma'am, so I can help my granddaughter.
Can you please elaborate?
Yes, she suffers from a genetic disease where growth is stunted. She needs an experimental drug that costs $10,000 per year.
Now, if the stock were to sell for its current price, would you be able to afford this experimental drug?
It'd be extremely hard.
You previously said that you're a shareholder with the company. How much have you invested?
Ever since I've worked for this company, I've invested. Some years I invested $100. Some years I invested $1,000. My stock in DAM is 90% of my life savings.
And how much do you stand to make if this proposed purchase goes through?
Almost $150,000.
Mr. Sussex, prior to sending Pat Kent this email, did he ever admit anything to you about the sale of his company, Delaware Auto and Marine?
Oh, I'll tell you what he said. He said he treated this company just like one of his children, and that he would never sell it no matter what the price.
No further questions, Your Honor. Cross-examination, Your Honor.
Okay, I hope you guys enjoyed that one as much as I did. He was quite animated, and that was good. The judge, if you noticed, on occasion you could see the judge that was sitting next to him was covering his mouth, trying not to laugh out loud, and not because he wasn't believable. I mean, there were a couple things. I mean, obviously he's supposed to be playing like a 55 or something year old man, and he needs his glasses, and we all know he probably really didn't need them. But he was very good at being a witness. But that's the point. I noticed more about the witness than I ever noticed about the attorney. Because she was simply a facilitator in getting the story out. She asked the right questions to get the story, and you did it hardly, I mean, did anyone else feel that way? Like they hardly noticed her at all? That's a good direct examination. He told a fantastic story. Your witness told a great story. So lawyers, what does that mean? That means you need to trust that you have prepared your witness sufficiently that they can tell the story you need them to tell. And that you can, that when you see them go off a little bit, maybe in a direction you don't want them to, you direct them back. Now that doesn't mean she didn't completely prepare the questions that were to be asked and the structure of that direct examination. She did. Did you notice the bad facts hidden in the middle of his testimony? Right? He gave his badge to some people. Right? He kind of was breaking some company policies of his own, but it was so hidden that you didn't really pick up on it. So those are some. That's why I think that is. And if you get the opportunity to get that this DVD, I think you should watch that again with that perspective in mind. She was hardly. I mean, she did a fantastic job. I thought. I haven't seen lawyers who've been practicing for 10 years do that great a job. She did a really good job. And that is the product of preparation and planning. Plan out that direct examination. They are so key to winning a case. So we're going to take a break. And that is, don't confuse being nervous with lack of confidence. Okay? What gets you past the nervousness is that planning and preparation, knowing that no matter how nervous you are, you're going to get the job done. I get nervous. I get nervous before I came here today about whether or not I was going to be able to help and teach you and do a good job in teaching you. And I feel like I put a lot of preparation, and I always feel like I can improve every year I try. But I still get nervous, and I still get nervous before I go into the courtroom. I mean, I get sick nervous, you know what I mean, before I go into the courtroom. But then when I get there, I know that I have spent a lot of time planning and preparing, and that I know no one knows my case better than I do. And no one knows the facts and the law. So don't confuse getting a little nervous or getting butterflies or even getting really sick before a competition for lack of confidence. Go in there, know you know what you're doing. So the second thing I wanted to share with you is the words I couldn't remember. The directed verdict is not permitted in the mock trial program. So just so everyone who's new to the program, I mentioned that in practice we use that, but in mock trial, don't waste your precious time making arguments like that, because it's, first of all, not permitted, and second, you are just wasting your time. I said 2 comments, but I want to listen to, no, I'll save the last one for the other part. Okay, so let's talk about cross-examination or thoughts about Perry Mason and Ben Matlock. Okay, how many of you know who Perry Mason and Ben Matlock are? How many of you don't? Let's see. Yeah, that's mostly the students. Okay. They're black and white typically. No. But Perry Mason and Ben Matlock were the early versions of like Law and Order and, your Boston Legal, which, oh God, don't even get me started. It's quite amusing. But one of the things that both Perry Mason and Ben Matlock could do on cross-examination is basically just finish the case and then you were done. And most of the programs ended there. So he got them on the stand and he just bent them over backwards and he took them out and they were useless. It was the most important witness on the other side and they were done. And you never saw a closing argument. That is not realistic, so just so you know, there's always a closing argument. So it's important that you do a good job on cross-examination, but in and of itself, cross-examination does not win your case. It is a piece of the puzzle, and an important piece of the puzzle. But as I stated earlier, you've got to start in your opening statement. You've got to get your evidence in on direct examination, and cross-examination, you can use it as a tool to really build up your case and solidify your own case. So let's get started with that. What's the difference between cross and direct? Well, the witness isn't friendly. They don't like you. They don't want to be cross-examined by you. And you know what? You're probably not real fond of them either. So, because they can hurt your case, and they probably said a bunch of stuff on direct that you just don't agree with. And so it's your turn to take them on. You can ask leading questions. We talked about that. The difference between a direct and a cross-examination from a lawyer perspective is in a direct examination, and we saw an extremely good example of that. I'm just a facilitator as the lawyer. I'm just getting my witness to tell their story. On cross-examination, I'm telling the story through my cross-examination. I'm keeping the witness as close to yes or no answers as I can. And I do that by using leading questions. Here's the thing that I wanted to, and I'll point this out on the example too. There's lots of ways to end the sentence. And so when you ask a leading question, a lot of people go, you were at the party that night, weren't you? You were there, correct? You know, so as they usually get into a pattern of using correct or right or isn't that right or isn't, kind of toss that up a little bit. There's lots of those like endings that you can use, but don't keep saying correct, 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 correct. And sometimes you don't even need that. Sometimes if you craft a well-crafted leading question doesn't require a correct at the end. You ask a specific question. It can be constructive or destructive. So what does that mean? Well, we'll go into that in just a second. Oops, I needed that. I hit the keyboard. The scope of examination. Normally the scope of examination is limited to the witness's testimony on direct. This is real life. And even then I think the rules have changed somewhat with regards to that. But mock trial allows you to go further. Mock trial Rule 611B allows you to inquire into any relevant facts or matters contained in the witness statement, including all reasonable inferences that can be drawn from those facts and matters, and may inquire into any omissions from the witness statement that are otherwise material and admissible. That means if somebody gets up and gives a direct examination and the witness doesn't address those bad facts, well, under some rules, in some courts, you wouldn't be able to go in if it wasn't within the subject matter, the topical areas that were covered within the direct examination. But with mock trial, if there is information within a witness statement or evidence that was in someone else's witness statement that this person was at a location or knew something, and even if it's not raised in direct examination, you're free to raise it on cross-examination. So you're not limited. You can go into any facts that are in your problem. Be careful about unfair extrapolation, though. That'll make you look bad, too. So you won't want to do that. If an effective cross seeks concessions from the witness by asking questions where the answer will either strengthen your case with facts known by the other side's witness. Okay, so you have facts that you've brought out in your direct examination, and you want to corroborate those facts by using this witness on cross-examination. Well, you were present, and you saw this, and you heard that too, didn't you? So you want to make sure you talk about facts that witness knows that help your case. You also want to weaken the other side's case by attacking the credibility or the believability of the other side's witnesses. And we're going to go into more discussion about that. Tips for surviving cross-examination. Once again, you are testifying. I'm not going to go into detail because we've talked about that. You control the witness. You can control the witness without saying, just answer the questions I'm asking. Okay? You can repeat the question. That helps to control the witness. Sometimes when the witness is getting out of control, you may need to ask for assistance from the judge. But before you do that, you need to have used every tool in your toolbox to control that witness. I mean, including, which is what I don't like. I don't like it when you say, just answer the question I've asked. You can use it by saying, so you're not answering the question I'm asking, or you can do certain things to make them look bad that kind of brings them in line. Yes?
I have an amusing thing that happened to us last year. The witness said to our attorney, haven't you ever been in love? And he said, I'm the one that's asking the questions. Our attorney told the witness, I'm the one that's asking the questions.
What did the judges comment on that at all?
And I think they laughed.
So, I mean, that's a good control. I mean, you don't have to answer the question the witness asks you. If a witness asks you a question, it's your cross-examination. So your attorney handled it properly, handled it right. I'm asking the question. Now answer the question I asked you, which was blah, 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 blah. Don't quibble with the witness. So you've asked the question, you've repeatedly asked the question, and the witness is clearly evading answering your question. At some point, don't you think the jury is going, why won't they just answer the question? Okay? That says a lot to a jury. So if you're a witness being cross-examined, do you really need to struggle that hard? Because at the end of the day, doesn't it affect your credibility with the jury if you don't ever answer the question and you keep going off topic? Have a poker face. Haven't you ever been in love? I would want to laugh. I really would, but keep your poker face. Keep your lawyer face on. I mean, I commend the attorney who was able to handle that question. That's pretty funny. Save it. And what I mean, the argument for later. Don't argue with the witness. Don't. You can tell the jury later. Did you not notice that Mr. Krankle would never answer my question? I asked him directly this question, and he never answered me. Save it. You can use that. You can use that to attack their credibility. And then attack the credibility of the witness. So if there's things that you need to address about whether or not they were actually somewhere they said they were, whether they could actually see what they say they saw, you need to, and there's lots of, we'll go into the specifics about how do you attack the credibility in just a moment. So how do I strengthen my case? This is practical information, guys, okay? You're going to list out the core or indisputable facts about the case. You need to do this. Make a list. If those facts are indisputable, the witness must concede the fact or appear unbelievable. Remember, we talked about that. You need to use this witness to get in those facts that can't be disputed because it corroborates your witness's testimony. We use the other side's witnesses as our own witnesses by getting those facts into evidence, which will support our witnesses. So that's what we do. But the first thing is that you need to know what those core and indisputable facts are. That should be one of the first things that you do when you evaluate your case. Then you remember we talked about in the simplest way, if it walks like a duck and it talks like a duck, then it's probably a duck. Okay, that's an inference. The inference is that it's probably a duck. So you need to know what facts of what evidence they're relying on to have inferences so that the jury ultimately believes their side of the case. And then develop your case to show the improbability of those inferences. Okay, so I wanted to try to provide you guys a little bit of practical steps. So now what? So you organize those concessions and improbabilities by topic, and this will provide you the framework for your cross. If your question contains too many, and this is important, if your question contains too many facts or assumptions, it's too easy for the witness to avoid or explain. So break it down. I actually had something good. So let me give you an example of what I'm talking about. The question is, you claim that you acted in self-defense, yet on the day in question you ran over there, grabbed the loaded rifle, racked a shell, armed and fired at the man in the green raincoat who was fleeing from the other direction. Isn't that true? No. I mean, only one thing has to be untrue. The green raincoat, right? It wasn't green, it was blue. And the witness can answer no. That's a bad question. And you just lost a lot of evidence, right? Okay, so what's the better approach? You claim that you ran to the gun, correct? And you then picked it up, right? You racked the shell. Isn't that your claim? So the rifle was ready to go. It was ready to fire, right? You then aimed it at the man, correct? At his back, right? So he was moving away from you, wasn't he? It's a claim for self-defense. Sorry, I forgot to tell you that part. But he's running away from him. So if he's running away from him, it can't be self-defense, right? So then if you ask that first question, you lost everything. But if you break it down and get those questions where there's indisputable facts, then you're going to be much more successful on your cross-examination. So what I've shared with you, how does that work in practice? How do I do that in practice? Okay, let's use a party store robbery as an example. The victim identifies her former boyfriend as the robber. It's the defense's theory that the victim is a scorned woman, and the identification is false. So what's my analysis? I'm going to break down, I'm going to look at the core facts, right? And I'm going to look at the theory. There are three parts to the defense's theory. First, there's a relationship between the defendant and the witness. What is the basis for the witness's ID of the robber? It's her relationship with the robber. Since he was the robber's wearing a mask, how are you going to prove that this witness could identify this individual as their ex-boyfriend? The witness was scorned. The eyewitness, the woman says, disputes it, but how do you prove it? How do you prove that she's not a scorned ex-girlfriend? You've got to, or otherwise you're not going to be successful. It's a false accusation. If this is true, if it's a false accusation, at what point in time did this witness create this scheme in her mind to identify her ex-boyfriend as the robber? You've got to figure those things out, right? Because you've got to break down the defense's theory. Well, let's evaluate the analysis versus core facts. We know that the facts show that the next customer arrived 2 minutes after the robber. So what can we infer from those facts? Well, that doesn't seem like enough time to plan a revenge scheme, does it? We know that the robber had the eyewitness lie on the floor and fired a shotgun inches from her head. Well, we can infer that the eyewitness thought, I'm going to die. So what else must be true? Well, if the eyewitness thought that she was almost going to die, why would you say, wouldn't you want the real robber to be caught? I mean, wouldn't you want that real robber to be caught? You wouldn't be like, oh, well, I can use this to get back at my ex-boyfriend. You wouldn't want that guy running around. So that's an inference you can draw from the facts to help break down and prepare your cross-examination of the witness. You can use these inferences. And then the second one is, with no time to plan, how did the eyewitness know where the robber was? How did she know? It just doesn't, these things, it's like, well, if I don't have time to plan this out, how would I know this is the person? Well, what if the robber had an alibi? And is this the kind of person that would risk a false report of a crime? I mean, really, is this defense probable? You've got to break it down. And using those tools we talked about just a few minutes ago will help you do that. Because you use logic, and at the end of the day, logic doesn't get you where the defense wants the jury to be. Okay, so that's cross-examination. I'm going to throw in a little bit here about rules of evidence for just a second. And the mock trial rules of evidence outline the rules for the introduction of evidence, including witness testimony. You need to be intimately familiar with the rules of evidence for the mock trial program. Be prepared to object during your opponent's direct examination and to respond to objections during cross-examination. You may not catch every objection, but if you're listening, which you should be, if your witness is sitting on the stand and you are already done your direct examination and the other side gets up, you need to be listening intently to what they're saying or what they're asking. It's difficult because you need to be preparing your redirect, right? So you're trying to listen to, and you should have already identified what points you want to make on your redirect with your witness. But most of that is going to be based on what happens on cross. So you need to be listening to what's going on, and your teammates are going to want to lean in and tell you things, but you've got to be paying attention for objectionable questions. And the same thing applies if you're going to be doing a cross-examination of a witness, and you need to be listening intently and have already prepared your cross. You need to be able, although you need to be prepared to wing it, because there may be something that comes up in that direct you're not expecting, but you also need to be prepared to object. If proper foundation for evidence hasn't been laid, if they're asking a question of a question that where the foundation hasn't been laid, or an opinion evidence or something along those lines. If you're intimately familiar with the rules, you'll know when to object. Evidence is hard. That's the hard, to me, as a practicing lawyer, knowing when to object is the hardest thing. And you don't want an objection you don't want to pass up an objection that allows evidence to come in that's hurtful to your case that shouldn't have come in because the proper foundation wasn't laid. Two types of objections. There are objections to form. The question is compound. Remember the question I read to you a few minutes ago? It's like this, that, and this, that, and everything but the kitchen sink. That's a compound question. That's an objection to form. Objections to substance. They're asking a witness to testify about something. They haven't laid the proper foundation. They haven't shown they have personal knowledge of a particular fact, and yet they're asking them about that fact. Those are just examples. Those aren't in any way meant to be all-inclusive. So that's my brief rule thing. Attacking credibility. These are the ways to attack credibility. I'm going to pull them all up. Means of knowledge. How do they know what they're testifying about? The strength of their memory. If you start asking them questions about what they did yesterday, and they tell you they can't remember, but they're up there testifying about something 2 months ago, I think you need to have a conversation with them about that. You know what I mean? You need to be asking them questions. Why is it you can't remember what I asked you yesterday, but you can about what you did yesterday? But you're expecting this jury to believe that you can remember with that much specific detail what happened 2 months ago. Opportunities for observation. Okay, so the person's testifying that, well, I saw the dead body lying on the living room floor. That's how I know, and I saw the person standing over them with a bloody knife. Okay, but when you see the crime scene photos, the blinds are closed. Did they really have the opportunity for observation? Pay attention to those facts. Reasonableness and consistency and inconsistency of testimony or evidence. Same thing. Is it believable what they're saying? And then bias or prejudice, basically the relationship to the plaintiff or the relationship to the defendant, how does that affect, or maybe even they just have their own prejudices and they have their own intent in testifying. They're protecting themselves in some way. So those are ways to attack credibility. And again, attacking credibility is based on the witness time. An alibi witness. You've got an alibi witness. Well, how does that witness recall the details of the day, the specific? Look for inconsistencies with the evidence. If you know, again, like the crime scenes, this doesn't apply to an alibi witness, but if the blinds are closed, well, you know that to be a fact, an indisputable fact. You need to be pointing that out. Character witnesses, you need to demonstrate their bias. Eyewitnesses, you need to demonstrate whether they really truly had the opportunity or to hear or see actions. An expert, you need to make sure they're qualified and had sufficient information upon which to base their opinion. Okay, going back to the rules for a minute. Character evidence. Subject to some exceptions, Rule 404 prohibits the introduction of evidence of character crimes and bad acts if it's offered to show a party acted in conformity with the character or bad acts. So what does that mean? Well, the defendant lied on his employment application and would lie again. Well, you can't do that. But what can you do? If evidence is offered for another purpose, in criminal cases where the defendant raises the issue of their own character, and evidence of witnesses' character. So read the rules, and that'll give you the specifics. I could spend an entire day talking to you about the specifics of the rules and how to apply them. But be as familiar with that and what you can and can't do as you are with your own case. Rule 607. The credibility of a witness can be attacked by any party, including the party calling the witness. You can attack the credibility of any witness, even your own. I don't think that's likely to happen in a mock trial situation. But you've got the witness who took 3 pills, and you want to come back and rehabilitate your witness. You know, you might try to find a way to do that, and there may be something you can do to attack just their memory for that moment. It's not really 3 pills, right? Rule 608 addresses bad acts that did not result in a criminal conviction. 4 basic rules. Trial judge may allow questioning, but has the ability to stop the inquiry at any time. So if you start going too far, the judge is going to stop you. Prior bad acts must relate to truthfulness. You're stuck with the answer you get. And good faith, you have to have a good faith basis to ask about the prior bad acts. So those are foundations. And when I talk about foundation, you need to be able to establish that you have a good, reasonable basis for asking these questions. So if the other side objects, you can articulate what the basis and what foundation you've already laid to support asking those questions. Rule 609 deals with criminal convictions. There are 3 basic rules. Prior convictions for offenses involving dishonesty are always available for impeachment. So remember, the other rule dealt with bad acts that don't result in criminal convictions. 609 deals with criminal convictions. So how can I use somebody's prior criminal record against them? I can't if it doesn't involve dishonesty, unless you may get to use other crimes unless the judge thinks it's too prejudicial. And Rule 404 still applies to criminal defendants. Okay, so let's watch. I'm getting better at this.
And therefore any speculation about their ties to terrorism would be just that and would be outside the scope of his personal knowledge pursuant to Rule 602. Yes, Your Honor. Mr. Kent, DAM is headed by a board of directors, correct?
That is correct.
And that board of directors has 5 members, correct?
Yes.
You are the chair of that board, correct?
I am. I was elected chairman.
3 members are your family members, correct?
Yes.
And 1 is your personal employee, your accountant, Lois Lane, correct?
That's right. She's a smart cookie.
And in fact, 3 of your board of directors have no affiliation with the company other than serving as board members, correct?
You can say that, yes.
That is how you stated it in your sworn affidavit, correct, Mr. Kent, is that right?
Yes, that's correct.
And in fact, it would be the decision of the board of directors to redeem the poison pill and allow the offer by MESS to go through, correct?
Absolutely. The board goes over any huge corporation decision.
Now, Mr. Kent, you did in fact create a business plan which you hoped would stimulate DAM's business, correct?
That is correct.
However, you did not hire a certified public accountant to make a valuation analysis of this business plan, did you?
No, we didn't feel that was necessary.
You have not brought forth any expert in accounting or finance in order to testify about the likelihood of your business's success, correct?
Well, that's correct. And if you want to ask some questions about it, I'm right here, though.
But in fact, you brought forth no documentation or witnesses, apart from your own testimony, which would corroborate that this business plan has any potential for success, correct?
Oh, well, I suppose Jamie could tell you about it, but I'm not really sure.
In fact, the only expert whom you brought forth in today's case was Chris Reed, correct?
No.
You have brought forth Chris Reed to investigate terrorism, correct?
Yes.
And as you stated on direct, you hired Mr. Reed after you received the offer from MESS, correct?
You know, that was part of my lawyer's deal. I think they got it.
And prior to that, you had no personal knowledge about the nation of Aladdin, correct?
No, I had heard about it, but I didn't really know that much about it.
But you did feel it was necessary to hire a terrorism consultant to corroborate your suspicions that they had international ties to terrorism, correct?
Absolutely, ma'am.
Which you had these suspicions prior to hiring Chris Reed, correct, Mr. Kent?
Man, it's part of the due diligence process that you investigate any company trying to buy you out.
Now you acknowledge that your sophomore enterprise is low, isn't that true, Mr. Kent?
And I do feel it undervalues the great American company that Delaware Marine is.
As of January of 2007, your entire board believed that the stock market price would be attractive to potential acquirers such as MESS. Isn't that true?
Yeah, that's correct, and that proves true.
Which is why you enacted the shareholders' rights plan, correct?
It's correct. The board voted one in.
And why you created your business plan. Isn't that true?
Not necessarily.
Now, however, you did create your business plan in order to try to stimulate your business and therefore to increase your stock market price, correct, Mr. Kent?
No, yes.
Now, the first step which you intend to take in this business plan is to support the dredging of the shipping lanes in the Delaware River. Isn't that true?
Well, yes.
And in order to do this, you must first secure the participation of the Army Corps of Engineers, right?
That's right. I'll have to give them a call.
And as to date, you have not spoken with anyone from the Army Corps of Engineers, correct?
No, that's correct. I haven't gotten around to that quite yet.
It is in fact May of 2008, correct, Mr. Kent?
I believe so.
And you enacted this plan almost a year and a half ago, correct?
Yeah, that's correct.
Yet you were telling the jury that you have not even begun to take the first step which you intend to take to increase the business of the AM.
Well, I'm sorry, ma'am. I don't think you understand my plan. I want to have the funding first, so I've been working on securing that.
However, you do first state in your business plan securing the participation of the Army Corps of Engineers, as you state in your sworn affidavit, correct, Mr. Kent?
Yes, that's correct. I just feel like we should have the funding before that.
And as of right now, there are absolutely no contacts between anyone from the Army Corps of Engineers and anyone from DAM, correct?
No, I have not contacted them yet.
Now, the second step which you intend to take is to retrofit the facilities at the Port of Wilmington to accommodate larger ships, right?
Absolutely.
And in order to do this, you must first secure $100 million of funding, which DAM does not currently have, right?
No, that's correct.
Now, you've already sent out various feelers to see if you can receive this funding, correct?
That I have.
However, you've only received one response to date, isn't that true?
Well, I've been talking in particular to one of my good banker buddies.
In fact, this is a personal friend of yours, right?
Yeah, I know Paul. We go way back.
He owns a local bank, right?
It's pretty local. It's over in Philly.
However, in fact, Paul cannot at this point support this retrofitting, correct?
Not at the time.
Because his bank is having to deal with some bad loan write-offs, and they have to get those back before they can even consider supporting this project, right?
That's correct. I think he's pretty tied up right now.
However, once you get this local bank gets those bad loan write-offs back, they'll be able to give you the $100 million you need, right, Mr. Kent?
I firmly believe that.
Now, the third step which you intend to take is to hire additional employees, correct?
That's correct. We're going to expand our family.
Which requires more funding, right?
Yes, it will. If we have more employees, we'll need to pay them.
And those are the only three steps which you include in your business plan, correct?
No.
You include retrofitting,
Yes,
supporting the dredging of the Delaware shipping lane,
that's correct.
and hiring new employees, correct?
Yes, but each section has quite a few subsections. I wouldn't really categorize it as having only those three sections.
However, at this point, Mr. Kent, you cannot go ahead with a single step of your business plan, despite the fact that you've enacted it for over a year, correct?
No, it's not correct. I could go out in the hall and call the Army Corps of Engineers if you'd like me.
However, luckily, you have 10 years to make that phone call to the Army Corps of Engineers. Isn't that true?
I intend to get it done pretty soon.
Now, you don't include anywhere in your business plan to increase the security of your port, do you?
Not at this time. I feel that we're constantly improving security. You can ask Amy about that one.
And in fact, you don't include anywhere in your business plan plans to bring in new commodities in order to stimulate the AM's business, correct?
New commodities?
Yes, you don't include anywhere in your business plan trying to bring in shipments of Texas Hold'em playing cards because you believe that it will help to bring in more revenue, correct?
Actually, we've already got the Texas Hold'em cards coming in this time.
You didn't include that anywhere in your sworn affidavit or in your business plan, did you, Mr. Kent?
No, I didn't think that was necessary. We've already heard it.
Now, let's talk about what you're aware of in today's case. You are aware that shareholders owning more than 51% of the shares of DAM have already tendered their shares, correct?
Yes, that's been brought to my attention.
In fact, you answered it in your answer to the complaint by MESS, correct?
That's correct.
And in fact, you own 40% of the remaining 49 shares which have not been tendered to this date, correct?
Yeah. I'm not too good at math either, but I think that sounds about right.
You do state in your sworn affidavit owning 40% of the shares of DAM, correct?
Yes, that's correct.
And 100 minus 51 is 49%, which remain untendered, correct?
Yes.
Now, in fact, you've also been approached by shareholders such as Aaron Sussex, who begged you to redeem the poison pill and allow the offer by MESS to go through, correct?
Aaron has emailed me about it, but I haven't gotten around to actually personally speaking with him about it.
Despite the fact that he is begging you to look out for his best interest by redeeming the poison pill, correct?
Ma'am, you have to understand that looking out for a stockholder's best interest doesn't necessarily constitute looking at the immediate payout.
Now, as you've already stated, you hired Mr. Reed in order to corroborate your suspicions that there are international ties to terrorism with the nation of Alliance, correct?
We asked him to investigate, and that's what he returned with.
However, you are making this decision to refuse the poison pill based on matters of national security, correct?
That is correct.
But Mr. Kent, you've never become aware of a terrorist attack which could be linked to Deborah O'Terry, have you?
Not particularly.
In fact, you're...
You guys want to continue to watch it? It's pretty long. She does quite a few things well there. One of them was near the end. He made a statement. That's going to happen. You can't completely control the witness. You just got to do your best to control the witness. She didn't quibble with him. She didn't argue with him. He didn't say anything that he hadn't really already said. Okay, so that's kind of an example of when just to let it go. Don't waste your time. She's making great points for her case. And she's got a very well organized cross-examination. She's telling the jury what she wants the jury to hear. And he's answering her. Correct. Now, the only criticism I have is the correct. So, there were a lot of questions she asked that she didn't need to say correct at the end. We all have idiosyncrasies where we do those sorts of things, where I personally tend to in depositions say, okay, like I'm moving on, but instead of just moving on, I say, okay. It's just a word I use as a filler of that time, from moving from one place to another. So be careful how you craft your questions. A lot of times you can craft cross-examination questions that don't require correct at the end of it. Or isn't that so? Or isn't that true? Those sorts of things. So she otherwise, I think, does a fantastic job of a cross-examination. In fact, I picked this one because I thought it was the best out of the 6 lawyers that got up and did cross-examinations. She was clearly knew her stuff. She hardly ever looks at the podium. She knows what she's trying to get across. And, if you feel the need to, follow, you need to, I think there were a couple times when it appeared to me she might have been a little surprised by something he said. And she was she knew his testimony so well. She could say, well, you didn't really say that in your affidavit, right? So, she knew that so well. So you need to have broken down the affidavit of your witness so well that you can go back and point to a specific thing. You know that when they're not being completely honest with the jury, or they're adding a little, something to what they're testifying about. And that's really important in cross-examination, especially if you're going to impeach a witness. And impeachment can be kind of scary. When do you do it? How do you do it? Well, you need to, like I said, you need to have broken down their affidavit, their written statement, their sworn statement so well that you can point to a specific thing. And every one of the mock trial cases, you're going to have sworn affidavits where they've signed the affidavit. And, you need to ask the question. You can't just, you realize they lie, you can't just walk up to them with their affidavit. You need to lay the foundation for impeaching them. And it's also a really good tool in controlling the witness, because she's done it a couple times where she says, well, that's not what you said in your affidavit, is it? Well, that's the first part of laying the foundation. And if they said, no, that's what I said, well, now you need to impeach them. So you need to pull that affidavit out, and you need to say, on such and such day, did you not give a sworn affidavit regarding the facts of this case? And they're going to say yes, and then you're going to ask to approach the witness, and you're going to put the affidavit in front of the witness, and you're going to say, isn't that your signature on page 2 of the document I put in front of you? Yes, Your Honor, I'd like to, use this for impeachment purposes, or however your coach has necessarily taught you how to do that, and you're going to direct that witness to the specific line that they said something completely different, and you read it, and you ask them. Here in your affidavit, it says, blah, 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 blah. Isn't that correct? Isn't that what this affidavit says? and they're going to say, hopefully, yes, they're not going to continue to lie. But that's how you do it. You don't give them the opportunity to read it, because the minute you allow them to read it, they're going to try to explain it away. So that's kind of impeachment. But reserve it. Don't just use it frivolously. It takes time out of your schedule. Out of your time. It's not something you expect to do in a cross-examination, and your time is always running in mock trial. So we're going to move on to closing statements or closing arguments. We're going to bring it home for the jury. We're going to tell the jury what they need to do and what the evidence has shown. What is the role and function of the closing argument? How do you incorporate these and theories, and how do you make a closing argument effective? And how do you format it? So let's start with the role and function of a closing argument. It is your opportunity to tell the story as the evidence has played out in court in its entirety, without interruptions from and without formality. So you get to tell the story the way you want to tell the story. You can argue about the evidence. You can argue what the evidence shows. You can argue what the witness has said. You can tell it, but you've got to tell your client's story, and this is the first opportunity that you get to really do that with the evidence in. It's only as successful as the preceding stages of trial. You don't get to argue about evidence that didn't come in. So for those of you who are doing the closing argument, once again, you can't have a script, because every time you're going to go into competition, what's going to happen in that competition, what evidence the judge is going to let in, is always going to change. So you need to be prepared to adjust your closing argument to account for what evidence has come in, because you cannot get up there and argue about evidence that didn't come into the case. But you can draw distinctions. Well, like I said, it's only successful as the preceding stages of trial. I don't want to jump ahead of myself. So if you're not successful in getting evidence in and facts in and through testimony of your witnesses, you're going to have a problem when you get to closing argument. You have an opportunity to reflect upon and encompass the evidence that has been admitted into your case. Back to things and theories. How do I incorporate those into the closing argument? My theory. I'm going to communicate my theory, which you initiated in your opening, and hopefully you reiterated throughout the trial. Every witness that you did a direct examination of, and through all the cross examinations, you have hopefully you have formatted those examinations to continue your theory to move forward in the case. It must be logical. If it's not logical, the jury's not going to follow you. So you need to make sure that it makes sense. How you line up the evidence in your closing argument, that you get, remember we talked about inferences again, that you make sure you put, if it walks like a duck first, and then if it talks like a duck second, and then at the end of the day, you talk about the fact that it is in fact a duck, ladies and gentlemen. It's got feathers, it's yellow, it's a duck. The application of your theory to your argument must be believable. So this is important. That's why when we talked about the theory at the beginning, we talked about that you need a single paragraph. And you need to do this after you go in and you evaluate your case. You need to synthesize, you need to take all that information and make one paragraph and say, the defendant didn't do it because the evidence shows da-da-da-da-da-da-da-da-da-da-da-da-da, and the law says you have to prove blah, 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 blah. One paragraph. All together. And that is how you're going, that right there is going to be the basis for everything. And so if what you say in that paragraph doesn't make sense, isn't logical, and isn't believable, then you need to redo it. Some people say, and it must be legally sufficient, so don't misstate what the law requires you to prove, or what the law requires the other side to prove. Don't do that. Be very clear to the jury what the law requires the evidence show. Some people say, and I find it helpful to write my closing argument first, because it sometimes helps me take all the facts that are in my head and the law and try to outline at the end of the day how I want the evidence to play out in detail. And so then I backtrack from that into trying to figure out which witnesses are going to get in those facts for me. And it also helps me figure out how to deal with my cross-examinations as well. So some people think it's a good way, some people don't. I do, but it's, I always say, you can try it. If it doesn't work for you, try something else. But I think it's a good way to start out. It makes you synthesize those facts down. Now, what about themes? Must be consistent presence throughout the entirety of the trial. That promote, protect, preserve, and you didn't get the opportunity to watch the entire video as I did. There were witnesses who were talking about protecting the business, promoting promoting the growth of the business, and they're talking about that. They're incorporating those themes throughout, and then as you'll see in the closing argument, because I did select that side's, no, I didn't select that side's closing argument actually, but in the closing argument, if you watch the video in its entirety, they bring it from the top all the way through the witnesses to the bottom and to the closing argument. It is very persuasive. You walk away knowing those those 3 words. Okay, it should evoke shared beliefs and common values. Do you remember how in the opening arguments she was like, the things that we Americans hold dear. These are the things that we Americans hold dear. Well, he does this in the closing argument as well for that side. And that's pulling at you. It's tugging at you as an American, saying, don't you want to protect our country? That's what we're trying to do. That's themes. That's invoking shared beliefs. That's getting people moved from the heart. A theory moves you from the head. The theme moves you in the heart. You want the jury to feel it here. And if you do that successfully and you have a well-balanced theory, you're going to move the jury. And, well, the judges are going to think you did a really good job. So, in this case, okay. You must explain to the jury why a verdict in your client's favor is morally desirable. It's just desirable, period. I mean, we can take the morally out and just say it's desirable. If you, in your closing argument, don't tell the jury why they should come to the conclusion you've come to, you haven't done your job in a closing argument. Okay? Don't assume the jury, don't talk to them like they're kindergartners, but don't assume the jury has followed your logic as succinctly as you have. Lay it out for them. And you must demonstrate that the evidence that's been admitted, in fact, supports your claim. Just like you have to show it supports your theory. So tell me, how do I make a closing argument effective? Well, you're going to use conclusions. You're going to tell the jury, this equals this. A plus B equals C. Okay? And that's logical. That makes sense, doesn't it? That's how you're going to do it. It doesn't make sense that this person would say they saw my client standing over the dead body when the blinds were closed, ladies and gentlemen. How do you see through the blinds? Make logical conclusions. Make inferences, just like what I did. The blinds were closed. No one can see through a blind. That's an inference. Explain the importance and relevance of the details and the circumstantial evidence, especially if you have circumstantial evidence. You have to explain how all that circumstantial evidence leads the jury to the conclusion you want them to be led to. Either it's not enough, it's not good enough, this is all circumstantial, it's not good enough to get you to that point, it's not enough under the law, or it is enough. But be specific about the evidence. Use analogies and stories. Comment on and compare the motive and credibility of each witness. You need to talk about each witness. My witnesses are great. This is a great guy. He's a family guy, or he's a good businessman. He's been running this company for 40 years. Their witness, they put up this bought and paid for expert who's going to tell them whatever they want them to tell them because they're paying for him to tell you that. Those sorts of things. You need to build up your witnesses and then attack the credibility of the other side's witnesses in your closing argument. You must address each and every witness. Don't be afraid to do that. All right. Let's continue. Discuss the weight of each relevant piece of evidence That sort of goes back to the previous discussion we talked about with witnesses too. So each piece of evidence that you have, you need to talk about. Each piece of physical evidence, okay? You need to talk about how either it's not good enough to prove the point, it doesn't really make sense. You know, what they're trying to get you to infer from this piece of evidence is just not logical, or this is a better piece of evidence than this, you know. So you just need to walk through each piece of evidence that's been admitted and either discuss why it's not good enough to support the other side's case, or why it's good enough to support yours, and how it ultimately leads the jury to the conclusion you want them to be led to. Discuss the demeanor of the witness. Once again, remember we talked, and this goes to credibility too. I mean, Mr. King got so hostile when I asked him a simple question and he was hostile with me and he wouldn't even answer me. You saw that. It was a basic question. Why was he so hostile about this unless he's got something to hide? I mean, those sorts of things are important when discussing witnesses. And you need to most definitely point out inconsistencies, implausibilities, errors, and contradictions in the other side's case. And you've probably already done that with their witnesses, and you hope the juries come along with you because you organized your cross-examination so beautifully, and you were the one testifying, and you hope that they followed it, but remind them, okay? Apply the law to the evidence presented. You need to tell the jury what the law is and how the evidence supports the application that you're seeking of the law to the facts. Either it's not enough. If you don't have the burden, it's not enough. The other side has the burden. It's not enough. If you have the burden, it's more than enough under the law to meet your burden. And elaborate on the moral theme of the case. Now, I don't know that I put in here this, and I need to probably go back and look. But if you are carrying the burden of the case, you need to point that out to the jury, and you need to tell the jury, we have the burden of proving to you by preponderance of the evidence, and we've done that. And here's how we've done that, okay? And then if the other side has the jury, you can say, they haven't met their burden, ladies and gentlemen. Their burden is this. That's what this, the preponderance of the evidence requires this, and there is simply just not enough evidence in this case to meet that burden, and here's how, and break it down for the jury. But always talk about the burden. Don't skip who's got the burden and whether that person's met the whether that party's met the burden. Okay, so what is the format of closing argument? For those of you who have done this before, this is not news to you. The plaintiff or prosecution goes first, and they do their argument in chief. When you're the prosecution and in this competition, you want a rebuttal. Okay, that's the benefit of being the plaintiff or the prosecution is you get the last word. Make sure you reserve the time for it. Make sure you know how much time you need for it. And really, in your rebuttal, you need, you're going to deal with your case in chief initially, and you're going to talk about all the things we've talked about. And in your rebuttal, you're going to have your points on that, very succinct points about the things we talked about. Maybe what the elements of the claim are and how you've met it. But you really want to use your rebuttal to address what the defendant has said in their closing argument. Some of the rebuttal is prepared, but most of it is not. Most of it is winged. You need to be prepared to just step right in it. I mean, I'll tell you, in one of my experiences, I had a lawyer on the other side. I was the plaintiff, and which is typically not where I sit. But anyways, I was the plaintiff, and I do civil work. I don't really do a lot of criminal work. And the defense counsel got up, and he said something very flippant to the jury. He thought he was being cute and had said something, and he was trying to attack the credibility of the witnesses I had brought in who had come from England. One was from England, and one was from Dallas, and we were in Tulsa, and how I drugged these people in from other places to tell this business how to operate in Tulsa. And it was really about prudent business operation. And so I said, that was a good opportunity for me to stand up and say, well, ladies and gentlemen, I guess here in Tulsa we live by a lesser standard than the rest of the world in how we operate business. You should be insulted. You should be insulted that that's how the defendant feels about operating its business here. Okay, so the door was open for me. I hadn't planned on saying anything like that. But when jurors approached me, there were two that approached me after the trial, later, they called me in my office. They said, "You're right, he did insult us. You were so effective when you got up and told us that." Well, okay, so point those out. My point is you have to be able to wing it. You have to be listening at all times. And so, yes, part of that rebuttal is prepared, but part of it is responsive. Defendants, you're in the same boat. You're in the same boat. You're listening to the plaintiff's argument. So you need to save time in your argument in chief to respond specifically to what the plaintiff's closing argument has been in that round of the competition. So always be able to wing it, in part. So, customary ending joke. Anyways, comic. So the prosecution bears the burden of proof, and the defense bears the burden of distorting said proof. So, tell the jury what you want. The jury needs to know what you want it to do. We want you to rule in our favor. If it's about damages, how much you want. Don't ever forget to say that. Don't ever forget to tell the jury what you want. It's important. If in a civil trial, tell them what their verdict should be and how much money. So your verdict should be in your client's favor and how much money they should give your client. Defendants, tell them how the verdict should not be in their favor and that why the plaintiff is not entitled to a single red cent. In a criminal trial, tell them what their verdict should be. So, if you're the prosecution, you've met your burden, and the defendant is guilty. Guilty, guilty, guilty. And if you're the defendant, this is prosecutorial abuse, and there's not sufficient evidence to prove my client is guilty. Okay? So always ask. And I appreciate everyone's time. I'm going to show you the last clip of the closing argument, and I thought it was a fantastic job at the national level. And I think that, before I start this, I'm pretty confident that Judy would like to meet with the coaches after I play this clip. And the students can stay here. And we can watch some more of this fun stuff.
Which DAN does not currently have. This plan is a pipe dream. It's not.
Your testimony in this case, how do you respond to that?
The DAN has a duty to promote, protect.
Nothing more particularly special about that exhibit than the others. The jury will consider them all, and the jury will together. Yes, Your Honor.
Yes, Your Honor.
Nothing further. The defense rests, Your Honor. Yeah.
Okay, before I start this, though, I do want you to recognize that she takes the other side's theme and uses it to her advantage. So pay attention to that. And that's winging it, ladies and gentlemen, because I can promise you she hadn't heard that before.
So, prepared to close?
Yes, Your Honor. May it please the court, opposing counsel, members of the jury. The defense was right about one thing, that DAN has a duty to promote, protect, and preserve the best interests of its shareholders. Yet all we have seen from Pat Kent and the board of directors is the promotion of false hopes, the failure to protect their shareholders' rights to sell their shares of their own volition, and a desperate attempt to preserve a failing company by bringing forth ridiculous and unfounded allegations that my client or the Nation of Aladdin have any ties to international terrorism. Today, we the plaintiffs have met our burden to prove by preponderance of the evidence that DAN through its board of directors has breached its fiduciary duty to its shareholders. Furthermore, the defense has completely failed to carry its burden to prove that MESS or the Nation of Aladdin have any material ties to terrorism, or that the proposed business acquisition poses a threat to national security. Justice Steele charged that if it is shown that by employing the poison pill, DAN's board of directors have failed to act on an informed basis, or have failed to act in good faith, then they have breached their fiduciary duty to their shareholders. You have seen the lack of information in Pat Can's business plan, which he is promoting to his shareholders as a reason not to sell for at least another 10 years. He wants to dredge the shipping lanes of the Delaware River, yet has no idea whether or not the Army Corps of Engineers is interested in supporting this endeavor. He needs $100 million to retrofit, which DAN does not currently have. This plan is a pipe dream. It's not made in good faith. And while Pat can't waste around to see if luck goes his way, his shareholders are left in limbo, hoping that Pat Kent will come to his senses. Justice Steele will charge you that in coming to your verdict in today's case, you'll be submitted 3 questions. The first is whether or not you believe the board of directors of DAN have breached their fiduciary duty to their shareholders. Pat Kent admitted to you that shareholders owning more than 51% of the stock of DAN have already tendered their shares, and that shareholders such as Aaron Sussex have pleaded with him to look out for their best interests, redeem the poison pill, and accept the offer by NESS. The evidence demands you answer yes to this question, members of the jury, and find that DAN's board of directors has breached its fiduciary duty to its shareholders. Your Honor, at this time I reserve the remaining time for my rebuttal.
All right.
I'm not sure at the national, I'm not that familiar with the national competition rules, but I would suggest that you reserve in advance. Yeah, okay. Yeah, you have to, is what Judy says. The amount of time you want for your rebuttal, because I'm not sure that that it's not the appropriate technique, at least at the Oklahoma level. Okay, so keep that in mind. Don't wait till the end to say I reserve the remainder of my time.